Mr. Horn, you may proceed.
Good afternoon, Your Honor. May it please the Court, Counsel. My name is Brad Horn. I represent the Department of Human Services in this matter. Initially, I would like to note that it is the Department's belief that it acted in a way consistent with all legal requirements imposed on the Department through state and federal law in relation to Dr. Colwell's claims. That said, the Department is very aware that the provider appeal rules that existed at the time in the Department were certainly not the model of clarity. And as noted in the record, noted in the briefing, the Department did go through subsequent rulemaking to modify the rules to make sure that they were clear in terms of what the Department considers to be its jurisdiction to address such claims. Had the district court's ruling been limited strictly to Dr. Colwell's right to appeal as a provider, subject to those rules that apply to his case, we would not be here today. The Department would disagree with the ruling and certainly feels that it doesn't have jurisdiction over that issue. However, it would continue and provide Dr. Colwell that.
Let me just interrupt you. Although I don't normally interrupt an apology or whatever, you're starting the argument, but these hearings that are kind of contemplated, or this hearing that Dr. Colwell sought, would this be, if assuming it went forward and you didn't prevail, it would be a hearing for the department to determine Dr. Colwell's rights under his contract with Delta Dental?
Correct, Your Honor.
So, because it strikes me as a little odd for an administrative agency to be adjudicating contract rights between a provider and a managed care organization.
You're not alone in that belief.
And part of those rights would be determined by the settlement agreement. Is the settlement agreement even in the record?
It is, Your Honor. I believe it's part of the confidential record.
Okay, because I don't recall seeing it. All right.
Yes, yes. And to your point, if you look at the appendix, page 9, Dr. Colwell's provider agreement with Delta Dental is in the confidential record. There is section 11 of his provider agreement, which addresses how to resolve disputes between the MCO and the provider. And it does not involve a 17A proceeding at all. So as I said, had the district court's ruling been limited to what the department admits were clearly not models of clarity in terms of department jurisdiction for provider appeals, we wouldn't be here today. There are two issues that I would like to discuss in oral arguments with you, time permitting. The first and the primary issue of great concern to the department is the concept from the district court ruling that a Medicaid patient can be held liable for claims that go unpaid by the Medicaid program. That's either directly or through a managed care process. Secondarily, the department disagrees with the district court's interpretation of 249A.4 subpart 11, and that is the statutory basis for jurisdiction of the agency to provide a dispute resolution. In relation to this primary issue related to the patient's liability for claims, this issue comes up in the most unusual way in this case. This is really a provider dispute about payment, but Dr. Colwell makes, I guess you would say, a backup argument that his patients have appeal rights as well. And he asserts this because he says if he's not paid for his claims, he will bill his patients. If he bills his patients, the patients will have due process rights. And therefore, he is a putative authorized representative of those patients, is entitled to appear and represent the patient's interests. The department disagrees in all respects with this argument. From a department perspective, there's no showing that the patients are aware of this proceeding, that they've been informed, that they truly have authorized the doctor to proceed with litigation on their behalf. So it's quite concerning from a department perspective there. But
I agree I think we can all agree the rules are not a model of clarity, but it strikes me under the old rules that what this was driving at with this idea that providers could represent the patients, it had to do with getting authorization for services like before the services occurred, not with collecting payments from, am I correct? Am I misreading that?
The department would read the rules the same way, at least the intent of the rules. And that is that a provider the provider doesn't have an independent right to bring a cause of action on behalf of a patient. The provider only has authorization under federal law to act as an authorized representative of the patient, to assist the patient to get the services that they constitute their property right under Goldberg versus Kelly. So the department would completely agree with your thought in that regard. The biggest concern that the agency has in relation to the district court's ruling in relation to the patient issue is this idea that the patient can be billed for services. And if the court looks at the Banks case from the Seventh Circuit, I think that, in all honesty, that case is on all fours with this particular scenario. It's clear that the patients in that case were billed for services that went unpaid by the Medicaid program, okay? And if you dig into the facts of the case, it's clear that the Medicaid patients were covered, the providers were Medicaid providers, bills were submitted to Medicaid for things that Medicaid would normally pay for in that scenario. The claims were not paid because the provider did not include sufficient documentation in one instance, and in another, the provider submitted the claim too late. In both cases, the claims went unpaid. Eventually, collection activities are initiated against the patient or the wife of a deceased patient. The Seventh Circuit held, looking at federal regulatory law, specifically 42 U.S.C. section 447.15, which very clearly delineates that only providers who accept payment from the Medicaid program of what Medicaid pays are entitled to even participate in the program. So it's clear from that language, from the ruling in the Banks case in which the court dismissed the case. Initially, the district court had dismissed the case based upon standing. The circuit court, I believe, dismissed the case based on failure to state a claim upon which relief could be granted. There was nothing to do for the patients because they had no due process issue associated with they couldn't be harmed, they couldn't be billed. In relation to the managed care setting, there are even more stringent requirements related to a provider billing a patient, and you find those in a set of patient protection regulations. So 42 CFR, Part 8.106. And subsection B of that provision provides that a provider may not bill the patient for covered services. And that's regardless of whether the state doesn't pay the MCO or the MCO doesn't pay the provider, the patient receives the services without an obligation to pay. Dr. Colwell's argument around this provision is to say, well, since the state didn't pay my claim, they're not covered services. And the district court agreed. The district court looked to an Iowa Insurance Division statutory definition of covered services and applied that to a federal regulatory provision to determine intent of the federal government, which we find is quite unusual. I have not seen that scenario occur before. The department disagrees. This court has said in the Becker case that Medicaid is not insurance. There's a distinction here. It's a public benefits program. The people in Medicaid under Goldberg versus Kelly have a constitutionally protected property right that they're entitled to. So it's very different from a contractual relationship like insurance. In addition, if you interject the reasoning from the district court, and that is that from the Insurance Division statutory provision, the definition of covered services is only those things for which payment is made, which may make sense in an insurance setting. It doesn't make sense in Medicaid. When you interject that concept back into the federal regulation, it is now circular because it says the provider may not bill the patient even if the provider's not paid as long as the provider's paid. It makes no sense at all. So from a department perspective, this is the most concerning aspect of the ruling. We believe that if it stands, any time that the Medicaid program justifiably and correctly denies a claim of a provider, then the provider is entitled to bill the patient. And this, in essence, it converts all payment provider disputes into a patient dispute. because it becomes then an allegation that the patient was given their due process, their property right under the law, then it was taken away financially, and now they have due process. It's very, very tricky concepts, but we do believe that this would take Iowa out of compliance with the federal Medicaid law. Any questions in that regard? The second issue in the time that we have left is the court's interpretation of Iowa Code 249A.4 subpart 11. And quickly, the federal Medicaid law was put in place in '65 when President Johnson signed it. 2 years later, the Iowa legislature implemented its initial version of the Iowa Medicaid program. The Iowa Medicaid program, as initially implemented in 1997, used the exact same language in terms of those people who were entitled to due process under the law. And that is this phrase that, and I paraphrase, an individual whose claim for medical assistance is denied or not acted upon in a timely fashion. Again, if you look back at the Banks case, page 243 of that opinion, it's very clear that the Secretary has interpreted this obligation under federal law to exclude coverage of providers in the obligation to provide due process. The obligation under federal law only extends to, I use the phrase patients, but that's quite inappropriate. It's an individual who is applying for medical assistance or an individual who is receiving medical assistance. But very expressly in the Banks case, pursuant to the Secretary's interpretation, it does not extend to providers. Providers are just treated differently.
What strikes me as odd is under Dr. Colwell's interpretation, if he had been Dr. Colwell PC and not Dr. Colwell individually, he wouldn't have had any rights, even under his interpretation. Is that correct? Because he's no longer an individual then.
I'm not certain how to look at that. That's a good question for his counsel, Your Honor. Certainly the district courts, the theory here that since the word individual in the Iowa statute is not defined, but it is used in the word definition of the word provider, that somehow you can then assume that because of the inclusion, individual includes providers, which syllogistically doesn't quite work. That's A includes B, therefore B includes A, which at a very basic logic level you can prove wrong. That's carbon monoxide includes carbon and oxygen. Oxygen does not include carbon monoxide. So the syllogism is false at the very initiation of what the district court did in trying to interpret the phrase in Iowa law. And I think the core flaw in the court's logic is really if it had turned to what the Secretary of Health and Human Services and the interpretation that had been provided by the Secretary, it's very clear that the provider has no due process rights either under the federal statutory framework or Iowa statutory framework.
But you would agree that even if under 249A411 we were to decide that Dr. Colwell is not a provider under these confusing rules that were issued by DHS, he might still nonetheless have rights to relief. In other words, they're two separate paths. Do you agree?
There's a path as provider, and there's a path as a representative of the patients. I don't believe that there's some independent ground where Dr. Colwell might have an independent path to pursue something on behalf of the patients. I don't believe that exists at all. In terms of the provider right, obviously the rules are not models of clarity. The department certainly believes that the statutory framework that it's working under restricts its authority even to create due process rights in anyone other than an applicant or recipient for services, which is talking again about the Medicaid patient, that individual who under Goldberg versus Kelly has that due process right, and actually, as Goldberg says, a pre-deprivation due process right, which in theory, if you were to apply that to providers, one would wonder how you would do that. A provider submits a claim that you know is fraudulent, incorrect. Would you have to pay the claim because the provider is treated as the individual who would be entitled to due process in a pre-deprivation setting? The department is at a loss as to how to move forward if that is the law. I see that my time is about up. Can I answer any other questions for you? Mr. Horn, thank you. Ms. Brommel.
Thank you, Your Honor. May it please the court, opposing counsel. My name is Becky Brommel, and I represent the petitioner, Appellee, Dr. Robert Colwell, in this matter. Dr. Colwell is a dentist licensed to practice in Iowa and Nebraska. The issue in this matter all stem from a law passed in 2013 to expand Medicaid coverage under the Iowa Health and Wellness Plan, and in particular, the Dental Wellness Plan is what is at issue here, which was implemented in 2014. The Dental Wellness Plan expanded coverage to low-income, uninsured adults between the ages of 19 and 64 who were not eligible under the current Medicaid requirements due to the amount of their income. And to address your question, Justice Mansfield, about, isn't this just a private agreement? This is not just a private agreement. This is an agreement that stems from a state program.
It's getting, what would the nature of the hearing be? The hearing would be to before DHS would then be to determine whether Delta Dental complied with its contract with Dr. Colwell, correct?
No, it would be to determine whether or not Delta took the claim that was submitted by Dr. Colwell for a patient and whether it complied with its own coverage requirements in its contract with the department. So the department and Delta have a contract. Delta is the department's MCO for this. The department all the time reviews MCO-specific coverage decisions and determines, and they do this through the state fair hearing process in front of an ALJ, that's a DIA, ALJ, that then it can be reviewed for final decision by the department itself. So this is not just about the contract between Dr. Colwell and Delta. It's about Delta's requirements to the state in order to implement the dental wellness plan.
Can you give me a practical example of some issue where Dr. Colwell says that something was wrongly denied? One of these pieces of his claim that is not a contract issue, but is actually more of a overall Medicaid issue.
So they would all be specific coverage questions, but for example, one of the questions would be, I know one that comes up a lot is there's a procedure called alveoplasty, and I believe, I'm not a dentist, but I believe that is the preparation for your gums in order to implement dentures. And so we believe under the contract with the state, Delta is required to cover alveoplasty. What they are doing is denying that coverage for that patient for that service. So that is just an example of something that the dental wellness plan has a set of coverage benefits that is to apply to individuals who are qualified for the dental wellness plan. And Delta is ignoring those coverage requirements and denying claims that we believe clearly fit within the requirements, just like they would fit under the requirements of Medicaid. The only difference here is that Delta Dental is implementing the program as the managed care organization. So this would be no different than the medical managed care organizations not covering something that Medicaid is supposed to cover and having a dispute as to whether or not the claim fits within the coverage parameters. And I think it's important to remember also that the department is very involved in the process with Delta Dental. They are the ones that determine who's eligible for the dental wellness plan. They approve the providers as Medicaid providers prior to being a dental wellness plan provider. You can't be a dental wellness plan provider without being a Medicaid provider. They review and approve all the materials and communications that Delta sends out to patients, to providers. So, for example, one of the things that we've quoted to in our brief is the provider manual that gets issued to providers. And those are all statements in there that have been approved by the department. Delta cannot issue information to providers without approval of the department regarding this program. So it's not as if this is some off program that has no connection to the department or to IME. It is controlled by IME. It's just simply operated and administrated by Delta.
It's helpful to think of these in terms of a specific procedure. So alveoplasty, if he doesn't get reimbursed for that, is it legal for him to claim, to collect from the patients?
We believe so, because that is not a covered service at that point. And I would point you to a couple of items. First of all, Iowa Administrative Code Section 441, 79.6 sub 2 says that charges determined in accordance with department policy shall be the full and complete charge for the service, and no additional payment can be sought from the recipient for services provided under the program. Well, it's not a service provided under the program if it's not covered. Another thing which I think makes this abundantly clear, and again, as I mentioned, the department approves every statement that Delta issues for this program. In Delta's Dentist Handbook, which this is at Appendix Volume 1, page 468, it specifically says, if a procedure or service is denied, then it is not a covered service, and the billed charge is collectible from the enrollee if the appropriate informed consent is signed prior to delivery of the service. And the informed consent that they're talking about there is the consent that the patient recognizes that if their insurance does not cover the charge, that they are, at the end of the day, ultimately financially responsible for it. So we're not talking about a situation of what you may call balance billing. That's not what we're dealing with here. Balance billing is when a provider bills $100, only gets reimbursed by Medicaid for $80, and they can't go collect the $20. They can't collect the difference. That is clear, and we're not arguing that that is the case. What we're arguing here is that if a service is not covered, if it is wholly denied, and clearly Delta agrees with that, and the department agrees with that because they approved that statement, if it's not a covered service, then the billed charge, so the charge that did not get paid for, is collectible from the enrollee.
What if, and I suspect this happens some of the time, what if Delta denies it, not because of some fundamental conceptual disagreement about whether the charge is part of the dental wellness program or not, but simply they say, well, your documentation's inadequate, or you're procedurally, it's in the wrong format, or you haven't provided enough proof that this person was eligible, or those kinds of things that happen all the time. In that case, can Dr. Colwell go and bill the patient?
Well, I think first we would argue that those could still go through a state fair hearing process for an independent person to determine whether Delta was correct in making that analysis, because the ALJs can also determine not just, substantively, should this be a covered charge, but they can also decide things such as, was this submitted timely? Did it follow the requirements of the program? Those are all things that they can also decide. If at the end of the day, there is an issue with, let's say it's something that Dr. Colwell did, then I think that it is, perhaps more questionable as to whether he could blame that then on the patient, or whether he has to take responsibility. I think that comes down to a comparative fault, something that if he went to sue or try to collect from the patient could say.
But under your statutory interpretation, it's all or nothing, right? Under your interpretation of the law, he could collect from the patient.
I think he has the opportunity to. Now, whether the court that then sees that case, most of these would probably end up in small claims court. If the court that looks at that and says, no, this claim was denied because it was untimely, so it's not the patient's fault, it's your fault, that goes to the liability issue between the patient and him, not to the issue of whether he's entitled to the state fair hearing or whether he has the right to collect, to attempt to collect from patients in the first place.
Do I have this relationship right, is that the department or the state or Medicaid or somebody decides what will be covered and what's not covered?
Correct.
And then they put it out for bid, and they say, these are the things that covered, these are the things that aren't covered. If you want to be a managed care operator and charge a capitation rate per person, tell us how much you'll charge us to do it.
Correct.
And they're really not administering their own policy, they're administering a state policy.
Absolutely.
So the state decides what's covered and what's not covered.
Correct.
Now the question becomes, if your interpretation's right on that last issue, it seems to me that if I was a provider, although a lot of these people can't pay, I would just not file it timely, say it's uncovered, and sue everybody. Or pick my people who may have the means to do it, You know, they may have enough income and just untimely file it and then start collecting against them. That doesn't seem right.
And I would, and that I think the department raised that as they called that the unscrupulous provider issue. I think that would be handled honestly through IME, and the department has a program integrity process. They have a Medicaid fraud process. You can't bill if you can't go collect and not bill. That's pretty clear. If you believe it's covered by Medicaid or by the dental wellness plan, you have to at least attempt to submit that claim.
And if you're right that this procedure, and I can't pronounce it, is covered by Medicare, and Delta Dental is denying it wrongly, if you go through the fair hearing process and someone determines it is covered, then there's no issue about going back after the patient, is there?
Correct, because at that point, Delta is then required to pay it. And we believe that's really what the process should be, because the patient and the dentist have the same goal in mind, which is to get the insurance coverage to pay for it. Like you mentioned, of course, the dentists don't want to spend their time going after individuals who are on state assistance. I mean, the collectability of those cases is probably pretty low. So everybody has an
Why
interest.
doctors take less than the billing amount to take care of the collectability problem.
Absolutely, absolutely.
Now, you mentioned the capitation. Delta Dental is paid on a capitation basis by the state, am I correct?
Correct.
And then they pay on a fee-for-service basis to the providers?
Yes.
So why would, if I'm, DHS, why do I care about this whole dispute between Delta Dental? I want the services to be provided, but to get into these individual arguments about, individual services and how much they cost and what they're worth and that sort of thing, why would the department care?
Well, the department ultimately has oversight responsibility of the MCO. They can't just turn it over to the MCO and say, good luck, and, do what you want. There are requirements that have to be followed, and they simply can't, decide they don't want to have oversight. And I think as shown in the facts of this case, they clearly do have oversight. They tell they tell Delta what things they can and can't say. They tell Delta what they should, what they're required to cover and what they're not required to cover. And so they can't then at the end of the day say, never mind, we're never going to check up on you.
More complicated than that. If they're not paying according to the federal regulations what's covered, they're going to lose Medicare dollars. Because they're gonna,
the match dollars.
Medicaid dollars, they're going to be kicked out of the program.
Correct. I mean, they have a responsibility according to the federal requirements, they have a responsibility to oversee MCOs.
Right, they clearly do, but they clearly have the responsibility to oversee the MCOs, but do they need to get involved in payment disputes between MCOs and providers? And did the regulations and the law intend that? I mean, that's really what we're talking about
We
here.
believe they do. I mean, I think clearly, if you look at the medical MCOs, there are hundreds of those cases going through the contested case proceedings all the time. And that is to make sure that the MCOs are doing what the department would do if the department was operating its program, processing its own claims instead of farming that out to a contractor. So they still have that responsibility to ensure that those claims are being processed and approved appropriately.
Medical claims that you refer to, are those similar to this and sort of after the fact claims, or are they before the fact claims where a patient is saying, I need this procedure and I need it to be covered?
I can't speak as to all of them. My familiarity with them is that many of them are pre-authorization claims. But still, I believe that, especially if you look at the rules, and I think we've fully addressed how we believe 249A.4 sub 11 applies here in our brief, so I won't address that here with my short time left. But as you mentioned, even if you don't agree with Judge Gamble's assessment of what 249A.4 sub 11 provides, I disagree with the department's assessment that those rules are not the model of clarity. They are the model of clarity, they just don't like the outcome. They clearly state that, let me find the one provision here. So those rules specifically provide,
But it says, the one you're talking about is that denial was not made according to department policy.
that's one of them. So, and we believe that part of the department policy is the dental wellness plan, which is then what provides Delta Dental the parameters for coverage. The other one is the provision that says a provider is an aggrieved party when they have been notified that the managed care reconsideration process has been exhausted and who remains dissatisfied with the outcome. That's pretty clear. If you have a managed care decision, you've completed the reconsideration process, that's an internal process with the MCO, you've exhausted that, and you remain dissatisfied with the outcome, as a provider, you can independently have the right to request and obtain a state fair hearing.
Right, I'm going to have to pay for this question, but
Sure.
I will, under our rules. Reading those rules, the 7312 and 7313, that looks like an enrollee who has a dispute with the managed care organization. This gets back to what we're talking about, over whether a procedure ought to be covered or not. It doesn't appear to me to empower a provider who has a payment dispute with an MCO to.
I think we
Am
may
I
be looking.
misreading it?
Yeah, I think we may be looking at different provisions. So the provision that I'm pointing to is, and this is in the prior rules that have now been changed, it's section 7.1, and then within 7.1, there's a number of definitions that are not separately, there's not separate paragraph numbers, and there's a,
Right, but I'm cross-referencing the old rule on that, where I think it defines what the managed care reconsideration process is.
I would disagree, because I think this 7.1 clearly is putting it within the process of a provider. And if you look at the documents that we have in this case as well, Delta Dental specifically followed up with, after they denied the claims, they followed up with a letter saying, you have exhausted your reconsideration process and now may request a state fair hearing.
Ms. Brommel, thank you.
Thank you, Your Honor.
Mr. Horn, you may present your rebuttal.
Thank you, Your Honor. Justice Mansfield, you asked a question just then I want to follow up on, and it's about the old provision in the administrative rules that spoke to reconsideration. The very first filing I made in this case was a motion to dismiss for failure to state a claim upon which relief could be granted in the district court, and I noted in a footnote that in looking at this language related to managed care reconsideration, there is nothing in the rules today that speaks to managed care reconsideration. There was historically. So yeah, I made the note to the court that this appeared to be historical surplusage. The district court judge informed me that was
Here's
not
what
a proper
I'm looking at
analysis.
is 7312, appeal of managed care organization actions, and 7313, appeal to department. And that's the only reconsideration process that I can find in there. And that involves disputes between the enrollees and the MCO, but it does allow the provider to act as the enrollee's agent, which all makes sense when you're talking about a pre-authorization dispute. I mean, we all have that, where I'm trying to have some surgery or something and Wellmark won't authorize it, so my provider talks to Wellmark on my behalf. But that's not what we're talking about here, I don't think.
It is not. And again, if you go back into historical department rules dealing with managed care, they've changed over the years. And this particular rule related to managed care reconsideration process mentioned in 7, so the provider appellate rights. There is no reconsideration process that's defined anywhere in department rules today. There was one historically, and what that provided for was the provider's ability to help a patient following the conclusion of the appellate process for the patient's claim. So I made the point in the district court that this just appears to be something along the lines of historical surplusage. It's hard to make sense of it today. And again, these are simply not the model of clarity.
Did the old rule go out of effect? If I wanted to read the old rule, how far back in the IAC would I have to go?
A few years. And I can't say for certain. I could certainly provide you something in writing if you'd request, Your Honor.
Try and figure it out. Thanks.
My apologies. There was a notice, something in brief that I forgot to mention earlier. There was an argument that, well, there's a distinction between the individual statement in statute or rule versus a recipient. Recipient is more narrow, is the argument, and individual must be broader to encompass things like providers, to which the department very much disagrees with. A recipient, obviously under the department's statutes and under federal law, means someone who is already receiving benefits. An individual is someone, yes, a bit broader. That picks up the people who are applying but not yet receiving benefits. The argument is, well, the individual is so broad that it picks up provider, and we disagree with that analysis. There was a question asked about what would be the nature of this proceeding before an administrative law judge. And I believe it would be potentially looking at the coverage questions and whatnot, but ultimately it's going to be a question of, did Delta violate its contract with Dr. Colwell? I think it has to turn to that. Not only that, you have a copy of Dr. Colwell's provider agreement in your confidential appendix, again, page 9. The terms of the contract call for jurisdiction in courts sitting in Des Moines City, not in a 17A proceeding. As a matter of fact, I don't know how you would ever possibly operationalize the clause that's in Dr. Colwell's contract if you move this over to a 17A proceeding. There were comments about oversight. And yes, under federal law, DHS absolutely must oversee managed care providers. It has to monitor them all the time, make sure that the statements that they put in their documents are not violative of law. There was a comment about the definition of denied in one of the Delta manuals, which is, it's incorrect. If that statement is still there today, it's incorrect. A provider can't bill a Medicaid patient once a claim is denied. That's inappropriate, and if it's still there, it will be changed immediately. Oversight doesn't mean that everything that Delta says is necessarily then attributed directly to the agency. They are a contractor. They are not anything more than a contractor. And in relation to the claims of Delta Dental, the agency never adjudicates these claims, never sees the claims except it receives data later on of what was paid. Okay? So any adjudication that the agency may entertain is entirely outside of what it is customarily looking at. I see that my time is up.
Mr. Horn, thank you very much.
Thank you.
Ms. Brommel, thank you again. The case of Colwell versus Iowa Department of Human Services is now submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.